It's preparing.
It's being recorded and live streamed.
Okay, hold on. Okay, we should be good.
Okay. Okay, good evening, Hammond North. It's September 17th at 6:06 for our regular board meeting. And it will be a little bit different than the agenda because Tracy Smiley is still on vacation, so we're not going to have the treasurer's report. Um, for those in attendance, Randy Vaughn,
Here.
Jan Welch,
Here.
Chris Conti,
Here.
Tom Deeds,
Here.
Tim Fritz.
Here.
Okay. All right. So Greg, do you have a building manager's report?
Thanks, John. Good evening, everyone. Just briefly, and thanks to the board's assistant and everyone's patience, the mail delivery service to the building has resumed. The Postal Service agreed to continue delivering owner's mail to the building until Saturday, November 15th. So it's highly recommended, if you haven't done so already, to go ahead and establish a forwarding address with the postal office. And if those of you that may still be in transition or you haven't finalized the permanent address, you still can put a hold on your mail. I think it's for a nominal fee. I don't know that number off the top of my head, but you can do that for a 30-day period. So if you're concerned about you're right in the middle of a process of maybe moving to your permanent address, you can put a hold on your mail at the postal office. And then the Item 2 is that we are continuing to prepare for winter. We received the last of the items that were in storage for the fan coil units, so we're going through the process now of where to locate those that were previously ordered, and where to place them strategically to minimize any concern about freezing pipes over the winter. Currently, we have all the water shut off in the building. We're working off city pressure alone. All the boilers are off. Of course, we'll have to resume the boilers when the weather turns colder. But to conserve energy and costs right now, we do have pretty much everything shut down. We have all the domestic hot water shut off. So those are some of the things that we're going through right now to minimize cost and start preparing for the winter months. And that's all I have this evening, John, unless there's any questions. I think Tim had a question.
Greg, I just had a comment. I just wanted to make sure people do not hesitate on making those address changes. Margaret made her address change like 3 weeks ago, and she's still getting mail at Hammond North. So get that address change in as soon as you can, because the post office is not really on the ball on this thing. So don't hesitate. Don't wait until November 14th to make your address change.
Thanks, Tim. And let me add to that the postal delivery staff did tell me the same thing, that it takes time. The other one is that I got in the mail today a request for me to verify my address change, even though I filled out the form at the post office that scanned my driver's license. I thought it was done. They said I have to re-verify it. So I'm going to contact the postal supervisor who I talked with 2 weeks ago at the Hammond. I got his email address, so hopefully I can see what's going on with that. But as I'm sure we're not over with particular problems, and feel free to contact Groesbeck Post Office, but also contact the board, and we can pass it on to that postal supervisor. Any other questions to the board or from the owners? Okay, moving along to the next thing. Greg, as somebody has mentioned, I'm wondering whether you can summarize the delinquency, given Tracy isn't here off the bat, putting you a bit on the spot.
Sure. Currently, as through the August, it was actually the September billing, we currently have 57 folks in arrears, and that amount is of 642,000 and some change.
Okay, thank you. Invoices. We have, again, without Tracy here, there were five Finney invoices that, I will read off that the, board approved through unanimous consent, email motion. We finally, the last board member approved it yesterday, been working on this for a week and a half. So Finney invoice 44026 was for $4,500. And this was the general, bill for services. Then invoice number 44027 was $168. And that was a question of potential lawsuit with one of the owners, which I think since has been resolved. It's not about the two major law cases we have. Invoice number 44028 is $4,057.02, and that was for work on the Burnham case. Invoice number 44029 was $230 on the Croskery case, and 44032 was on the petition, and that was $33,687.20. So I don't know if just hold off the questions, and we're going to go through and vote on the particular invoices we have for August, and then we'll entertain questions. So I'll turn that over to Randy, if you can go through those.
Okay, since Tracy's not here, I move we approve Finney invoice number 44500 in the amount of $2,130.71. This is from August 18th.
Do I have a second?
Second.
Okay, Chris seconds. Any discussion?
Do we have a summary of what it was for, like we gave for the other ones, Randy, or maybe not easily?
Yeah, I don't, since I just got
Yeah.
these, no, I don't know.
Okay.
I mean,
could look it up, but
it is for general services,
Oh,
general board questions. All right, no comments? Any other comments, questions? All right, all those in favor? Okay, 6-4. Okay. All right, any other motions, Randy?
yes, I move that we approve Finney invoice number 44501 in the amount of $968 even, again from August 18th.
And that was for the Burnham case.
I believe so.
Is there a second?
Second.
Second by Chris? Any
Is that
discussion?
true?
Oh, is Tom raised his hand? Sorry.
Yeah.
Okay, recorded as Tom. Any questions? Okay, all those in favor? Okay, again, we have 6-4. All right, the next one.
I move we approve Finney invoice number 44502 in the amount of $70.50. Again, that was from August 18th.
Is there a second? And that
Chris?
one's Chris. And again, that one is for Croskery. Any questions? Okay, all those in favor? Okay, again, 6-0. And the last one, Randy?
The last one is a Finney invoice number 44503. This is for the partition action. It's for $34,952.51.
Is there a second?
Second.
Tom, seconds. Any discussion?
The only thing
10.
I want
I just want to make sure that everybody's paying attention here and sees or understands that there were 2 invoices in the last month now for $70,000 for the petition action. And this isn't going to stop if we continue down the path of the petition action.
to.
Tom, did you have a comment also?
No, the only thing I wanted to state is the fact that, remind everyone that we have already looked at these invoices before this meeting. We've seen them all.
Correct. Any other comments? All right, all those in favor? All right. Okay. All right, the next one is update on the sale of the Hammond. I don't know, does anybody else want to do the report about Randy Dickman and the national search? Randy?
Yeah, we received a couple of emails from Jordan that we're in the middle of the 60-day national marketing of the building. We had a tour last week of some investors who were interested. That was one group. And next Tuesday, we have scheduled 2 in-person tours and 2 virtual tours. The brokerage firm came in and they had a drone and they made pictures of everything in the building and outside the building with the drone. And they have set up I've not seen it, but they have set up a virtual tour that these out-of-town investors can take a look at the building and see what we've got here. Yeah, that's all I have there, but at least it's good to know that there are interested buyers out there and that things are happening. I hope.
Randy, there are some questions in the chat about a 30-day period versus 60-day period. I'm not sure what the questions are. I do know that the contract we have with Jordan Dickman expires on October 7th, and we hope to have the bids from these potential buyers by that time, and then we're going to have to make a decision. I'm not sure if people have other questions about 30 or 60 days. If someone misspoke or we need clarification, they should put it in the chat room again.
Yeah, it did get off to a little bit of a week and a half late start because of Labor Day. He didn't want to put it out right before Labor Day, a holiday. So they waited until the day after Labor Day to get it going. They will call for offers about the last week of September. And then by the first part of October, we should see what we have and go from there.
Tim?
There are some questions on the chat about you said that we've gone from 30 days to 60 days. People were asking how we went.
Did I
from
say
30
60? I meant a 30-day period. I don't, if I said 60, I'm sorry.
Yeah,
It's 30 days.
yeah. Okay. Yeah, that'll take care of those questions.
Thank you. All right. Any other questions? Again, as before, if owners have questions, please raise your hand electronically, and that way I can tell who's has a question and can recognize them. Okay, moving along, I think, Jan, do you have a report of the committee to sell?
I do, thank you. Can everyone hear me okay?
Mhm.
Okay. We have of an owner, a staff member and a board member who empty the ballot box. We never have anyone doing it alone. Today, there were 3 more votes in the ballot box, and the box was emptied by Tom Deeds and Mickey. And we now have 156 votes to sell. So that means there are 24. We are down to 24 votes that we need to have 100%. We have had good conversations with others and are expecting a few more votes to come in very shortly. The committee sent the information that was handed out at the owners meeting, both the financial information and the letter, along with a memo with a little more information to people who, according to our records, who have not signed to sell last week. And that already has resulted in a couple more votes. We have 3 weeks left of the national search, and several people have indicated that they would sign at that time or when they see the bids. So that time's getting close. So again, to recap in a slightly different way, we have 86.7% of the votes to sell and 13.3% remaining.
Thanks, Jan.
We're almost there.
Tim?
Yes,
Hey, Jan,
yes.
my question is, I know you guys are doing a great job and you have like a profile on each person who hasn't voted for the consent to sell. Are there any people that you don't have a profile on that you haven't been able to contact?
The word profile, we don't.
Well, I mean, you
Yeah, no,
suspect some
so
people.
there have been a couple people we had trouble contacting. I think we have most of those in now.
Okay.
A, a couple of them have come through. There were a couple people we thought we had the contact information, and then we didn't. There were a couple people that thought they had signed, and we don't have record of it. So we're really dotting our I's and crossing our T's now, and that's resulting in a few more votes as well. We appreciate every vote. I mean, I remember when it was 42 we were looking at, and that seemed like an unmovable number. Then it was 35, then 24. I mean, so we're nudging it along.
Hey, Jan, there's a comment. Chris Naporti made a comment on the chat, and he said he would like to be personally contacted. He has to leave the meeting, but he would like to
Okay.
be personally contacted.
Okay, great. I assume we have a phone number. I'm not sure.
I'm sure Greg's probably got some contact information.
Yeah, okay, sure. Great, thank you.
Any other questions of board members? Or from the owners?
Why
right.
are we still spending money on a partition action if we all want a direct sale?
It's a good question. The original view was that we should pursue both routes. In case one doesn't happen, we have the fallback. Clearly, as we all know, it's a very expensive fallback, beyond the money for the legal expenses. If we look at how much money they will have to spend if it drags on for a year, let alone 2 years, that is the budget, that is fees for everybody. It's a very costly affair. I actually thought the same question. But I think once you start the action, I think you have to keep going with it. But we may ask the lawyers about that.
But I don't think, well, this is just my personal opinion. I don't think we can stop it. We can't afford to. We have to take this through one way or another. And considering one person can hold up the sale on the direct sale, we have to keep going, in my opinion.
Tim?
I agree.
Yeah, that's what I was going to say is the reason that we're continuing the partition action is because we have 24 people who haven't agreed. And the law and the rules are we have to have 100%. I would agree if we got down to like single digits people, 3 or 4 people, maybe we could stall the partition action and quit spending some money on it. But with 24 people holding out, we don't have a choice but to pursue both paths.
Any other questions or comments? All right, we'll move forward to the next item on the agenda. And that item is the finding of the city building inspector. The city building inspector came and inspected the building, and she asked a very interesting question. She wanted to see the units that were the last ones to move out. And she looked at 2 of them in particular, and they had a good amount of furniture there, at least 1 bed, maybe 2. And she asked for information of what was going on with that. The board has reached out. We have 2 board members contacting each of these individuals. One of them has said that they have arranged a move out date. So I think we're pleased about that to happen. The other one is still looking for a place where to move out, and it's a very difficult problem. The board has discussed possibly cutting off the electricity if they're not out by September 30th. Another option is to basically to change the lock on the unit. So we're exploring options, but that's what happened with the city inspector, who has been here a number of times. She also pointed out, and we had to do a fix with the building, the '08 units, the railing, because apparently in dismantling the hoist, some of the railings got damaged. So we found a cost-effective method. Greg worked with the company, so all we did is put screws in some of the damaged the windows for the damaged balcony railings, and we resolved that one.
And no one is sleeping in the building, correct?
No one is, as far as we know, is sleeping in the building. September 30th is a deadline. We also have passed a resolution that nobody can be in the building 7 p.m. to 7 a.m. And we trust all the owners are abiding by that. There's as comments, as somebody says, nobody's living in the building, but there's an excessive amount of furniture that the inspector was concerned about. If we can go back one item, Jen, if you could answer David Rosenberg's question of, I know that the committee has grouped the people who object, and if you want to go over those general groupings of owners who object to signing the consent to
Sure.
sell form.
We've discontinued that categorization because things were evolving and people were changing their minds and mixing, and it just didn't make sense anymore. And we're down to such a small number that didn't make sense. I think I mentioned there are several people who have said they will sign when they see an acceptable bid, and when the national search is over. And there are a couple of people with legal concerns. The board has offered to have their attorneys talk to our attorneys. So hopefully we can resolve those. And that's about all the categorization that makes sense anymore. Which I'm pleased about that, actually.
Yeah, Tim?
Yeah, just so that everybody knows, this is the chicken or the egg problem that we've got right now, is that as long as we don't have the authorization from the owners to sell the building, we can't sign a contract. And some of the objections have been, I'm not gonna sign the consent to sell until I know exactly what we're gonna sell the building for and exactly what it's gonna cost us to sell the building. So this is chicken or the egg. If we don't have a consent to sell, it's very hard to make that final negotiation with the potential buyers, because they have a degree of risk out there that we are not going to agree to it, and we're going to end up going down the partition path. So that's the reason that we need to, every single person who has not signed needs to let us know exactly why they haven't signed and exactly what they need from us to sign. And to say, I'm not going to sign until I know exactly what the final agreement is, that's a very difficult hurdle to overcome.
Let me just add that Finney has said that they would not only will they meet with the lawyers and the owner clients, but they're perfectly willing to sit down with any group of owners who have objections to the form and discuss the form with them. And we haven't had requests from owners, but that is another route for people to understand, not just from us, but from the Finney law firm. Randy?
Yeah, I started to say, we can counter a contract with the contingency that we have to get 100% of all owners. And in these contracts, they're going to build in a due diligence period of either 30 or 60 days, and then another 30 or 60 days after that until closing. So we do have time in there for these people that do want to see the contract and look it over. So it is possible, but it's not very attractive to a buyer to see that there are, still 24 owners who haven't agreed to the sale. So it does hamstring us. Yeah, that's all I wanted to chip in with.
But the letters that we have received have said, I'm not going to sign until I know exactly what we're going to sell it for and exactly how much it's going to cost us to sell. And we
Right.
cannot do that until we have everybody's agreement. We cannot have a final contract
Right, not a final,
until
no.
everybody agrees.
Ginger?
Just a suggestion on that, because it is a circular argument and you can't do one without the other happening first. I'm not sure that all of those 20 or so people really understand that that is an impossible thing to happen. And I wonder if it would be worth the time and effort to put an invitation to those remaining to meet on a special Zoom meeting with the board and the attorneys all present, and try to hammer it out and let them say what they want to say and try to answer those questions in a way that it might start dawning on them that we're just keeping it in a circle, that they are actually preventing the thing that they want.
Ginger, I think that's a great idea, and I think Isaac made that offer at the meeting last week, at the in-person meeting. He agreed that he would meet personally or on Zoom with anybody who needed to have questions answered. So that's a great idea, and we're open to that. But we've had very little feedback since then about what the exact objections are.
So since those people don't want to initiate that by themselves individually, let's see what happens if the board initiates that and invites them. Each person gets an invitation.
We will. That sounds like a reasonable request.
Randy?
Yeah, a couple of chat questions, comments. One is, we have written that the reason 910 has not signed is that we have asked for a written assurance that none of the proceeds from the sale will go to Hunt or TRS. It seems that should be forthcoming so we can sign. It's not a question, but any comments on that?
18, 19.
Any
None.
other chat questions, Randy?
Yeah, it's time to release the names of the owners who have not signed, or agree on a date when the names will be released if not signed. Another one along that same line, who are the board members, current or past, who have not signed?
I'm not
Another
sure.
Another one, how powerful these 24 people have become. Amazing. Much like our country today, people seem to love voting against their own best interest. I think we just got political there.
Michelle?
Thank you. I just want to make a comment that I'm really concerned about the comments being made about the people who haven't signed. They have every right to make their decisions based on either advice from their lawyers or for whatever their reasons are. I also want to comment that I'm extremely frustrated that even if we do sell, we're still going to be locked in a legal limbo with the people who are suing. I want to ask a clarifying question from the board meeting or the annual meeting. My understanding is that our attorney for Finney told us that should there be a settlement in these lawsuits or any damages, that they would not be covered under our D&O or the insurance of the board. Is that correct? Yes or no?
As far as I know, that is correct, that the CNA has a letter, and I believe various owners with various positions on a number of important questions have seen that letter. It came out a year and a half ago.
Right.
And CNA said they would
okay.
pay legal costs, they would not pay damages.
Right. So what that means right now, and I just want everybody to be clear, this is complex. I want to sell the building as quickly as possible as anyone else. But I also want to say that the number that's been put out there that the plaintiffs in the Porter et al. Case is $2 million in damages. That's what they want. I just divide that by 180, and that's $11,000. I am very concerned about these lawsuits. We are all in the same boat, folks. We've all lost our homes. Many of us have been hemorrhaging money for 2, 3, going on 4 years. It is time to stop. I cannot fathom a reason why the lawsuits continue. I just can't. And I appeal to the to the to the people who are suing. I desperately appeal to them to recognize that your neighbors are suffering, and they are suffering daily, and we are left in this hellish limbo of not being able to move forward. And even if we sell the building, we can't disperse the funds until the lawsuits are done. And we have no idea how those lawsuits are going to impact our ability to sell the building. And I know people are sick of hearing this, but drop the lawsuits for God's sake. Let us all move on with our lives. And that's all I want to say, because I will be absolutely beside myself if on top of the $70,000 to $80,000 we have already lost because of this fire, I lose another 15 or 20 because of these lawsuits. So that's all I want to say. Thank you.
Okay, I think we should get back to the agenda, which is that the board did pass a unanimous motion that was that in terms of cabinets, appliances, and the lower level, that everything that anybody owns in the building, that they have to get it out by November 16th. That's
If
a
they
date
want it.
also. If they want it, yes, an important point. You do not have to take any of those possessions out. That date of November 16th is also something that I mentioned when the postal supervisor was here, that date, that's what was going to happen at that date. And he seized on that to say, good, that's a date when the mail would stop. And I think general agreement that that's a resolution of that issue. Jan.
Yeah, I just really want to clarify. No one is living in the building. No one. There are a couple of residents who have left a lot of stuff, and they are getting out whatever remaining stuff they're going to remove by September 30th.
Any other comments from the board on the question of possessions being out of the building? All right, moving along. I know that Jan, you gave your report. There were 3 more votes in terms of consent to sell. I don't believe there were any more votes on the reserve.
Oh, right.
Tom, you're going to try to get down to the building to count them. That didn't happen today, did it?
Yes, it did. I was
Oh,
down.
good.
Mhm.
Okay, do you want to report on that?
Well, Jan did. There were, we
On the
got
reserve.
3 votes to sell, but nothing on the reserve.
But I
Right.
thought we were at 145.
But the
Greg, do you
reserve is already
remember?
passed.
Okay, well, we'll talk about that later. But I think we're at the position that we think we have more than enough. We just want to double check. When we went through the consent to sell document, there are insertions, deletions, there are duplicate forms. So we just want to, we're going to double check that. And then we can finally say that what we have in the budget is accurate. That there's no annual allocation for the reserve fund.
Right.
All right, legal committee. Randy, you want to cover that?
Yeah, we have asked Ian Mitchell, who is representing us in the Porter and Croskery lawsuits. We have asked him to make overtures for mediation. At least we hope to get off a dead center with that and get something going. Yes, it's going to cost money. So even if we, yeah, I mean, these lawsuits are costing us money now, and as we continue them, they will cost us money, as Michelle was talking about. So anyway, but we have asked him, encouraged him to, and they are, he and the lawyer in the Porter case are discussing who to use for a mediator. So we hope to get some movement on that soon. I think that's really about all I can report that I know of.
Yeah, I mean, one of the things on the Crossview case, there are some offers going around, but I think at this point, there's no agreement on any offer, and I think the sides are pretty far apart.
Yeah. Tim's got a question or a comment.
I guess I don't have a question. I just wanted to make a comment. I guess the other thing that people need to know is this isn't something that just happened. We've been talking about mediation on the Crossview case for a while. So I think some people thought that there wasn't anything going on, but there has been stuff going on. It's just a slow process.
Any other comments? All right. The next report I have is the waiver of service forms. This basically is a form that there are two forms that the Finney Law Firm drafted up. One is for owners, one is for the banks. It's basically a form that says that they do not object to the lawsuit, to the partition lawsuit, and that they don't have to get service anymore on all the legal documents, and that for all intents purposes, they are really no longer plaintiffs in that case, defendants in a partition case. So one is for the banks, one is for the lawyers, so one is for the owners. We have reviewed a draft. It's gone back to Finney, and we're awaiting answers on those forms. Yeah, Randy.
Yeah, these forms would be offered to defendants in the partition action. We've had a lot of people say, well, I'm a defendant because I didn't sign the thing, but I'm really not against this. They understand that whether you're a defendant or a plaintiff, it doesn't matter. If it goes to partition and, the judge finally puts it up for a sheriff's auction, we all get our percent of ownership of the proceeds. So we're all in it together, even though we're divided into plaintiffs and defendants. However, you've seen the two invoices that we approved today for the partition action. They totaled, what did they do? $80,000, $70,000, 70 for the partition action. This would save us a lot more money if it ever comes to it, in that anytime something happens in the partition action, all the defendants have to be served. They have to be sent the documents that explain what happened, or the judge's decisions and all of that kind of stuff. When they sent out the original service on that, it came to like $30,000. And so if we have to do that every time something happens in the partition case, that's a lot of money. So if you are a defendant in the partition action, and if you don't have a mortgage, now if you have a mortgage, you're going to have to ride out to the bitter end. But if you are a defendant and you agree that if it comes to the partition action, that you will not contest it, that you will accept whatever the judge rules, and then it would be good for you to sign there's two forms, one for the mortgagee and one for our unit owners. It would be good for you to go ahead and sign that. It suggests that you consult a lawyer. Lawyers always suggest that. It basically says that you are guaranteeing that you indeed are the rightful owner of your unit, and that you submit to the court's jurisdiction. You don't think it needs to be moved to some other jurisdiction somewhere. And it also says that you are waiving any summons before the court. You don't want to come before the court and testify. And that you will consent, as I said, to the division of the proceeds minus any liens that may be against you, and that you will admit that the court's ruling is final. That's what it says. Now, it says all that in legalese, and the first thing there, consult an attorney. So yes, we understand that you might want to do that. But if we don't get a direct sale of the building and have to ride through this partition action for the next 2 or 3 years or so, this would be a nice thing for you to do for the association anyway, to try to save us a little bit more money in our legal fees that we will incur in the partition.
Thanks, Randy. Tim?
Hey, Randy, you and John are intimately involved up to your necks in this thing. Please define for everybody who are the defendants and who are the plaintiffs.
Well, if you can remember back, I know we've had you sign a lot of different things as owners. If you signed on as a plaintiff in the partition action, then you are one. Now, if you were involved in a legal suit, you probably, even if you signed, you probably were put in as a defendant, because our lawyers, if they're having an action against you, they cannot represent you in the partition action. They would be riding both sides of the fence. But basically, if you signed on to be a plaintiff, you're a plaintiff. If you didn't, you're a defendant.
I'm ducking out of a Zoom.
Yeah, somebody is not muted.
Virginia, Ginger.
So that's with the owners. Now, all mortgagees, all mortgage companies involved are defendants. And we've heard from some of them that they would like to speak in court. The hope is, well, the hope is we never get there, but the hope is that when the mortgagees realize that this is what they're going to get, after the whatever the auction price of the building turns out to be, and they realize that the unit that they have written the mortgage on, that's what it's going to get. We're hoping that they will just realize there's no reason to fight this. That's all, that's all there is. So we're hoping that that even though that a lot of them have written answers to the partition complaint, that they will give it up in the end and say, okay, we'll take the money that this unit has received, even if we're owed more than that. That's our hope.
So,
and Tim, I'm sorry I couldn't answer that directly, because there's
the simple answer.
There's 110 plaintiffs and 70 or 80 defendants, so I don't know who's what.
So the sort of simple answer is, if you signed on and agreed to the partition action, and you are not a defendant in any of the lawsuits, you're a plaintiff.
Probably so. Yeah.
And everybody else who either didn't sign on or was a defendant in a lawsuit is a defendant.
Actually, I think it's a plaintiff in the lawsuit. The plaintiffs in the lawsuit cannot sign on to be partition action plaintiffs.
Right.
Okay. And then people who did not sign the petition form are defendants. And the one exception is that we do have a few forms signed by people who are plaintiffs in lawsuits, and therefore they did not file as plaintiffs. They are defendants.
Right. Okay.
And if you really, I don't know why I'm saying this, but if you're confused and you really want to know, are you a defendant? Are you a plaintiff? Email the board, and I'll look at the filing, the lawsuit, and I'll see which side of the line you're on and let you know.
You're a good man, Charlie Brown.
Yeah, for now.
And in terms of these forms, that's one of the questions I asked Julie that Randy went through. If you have a mortgage, then you cannot sign that form. And my understanding, I needed clarification, is if there's a lien in your unit, then you can't sign this waiver form either. But anybody else who wants to sign it, who is a defendant, can, on the petition action, can sign that.
And if you do want to sign it, you can't sign it yet. They're not finalized. Is that right, John?
I think that's right.
Yeah, as soon as they are, we'll get them on the website. You can download it and go from there.
So any questions about that form?
There's a Lynn Saul asked on the chat, do we know if there is a lien or foreclosure on a unit? Does that owner still have property rights to consent to sell, or when are their rights forfeited?
I
They
think
do.
that's a question that we want to check with the lawyers, but as far as we know, and board members had internal discussion about that, that does not waive their property rights for ownership. But I'm just speaking for myself.
Yeah,
the
that's
way-
my understanding as well.
Yeah, that's the way I read it also. Is it you can forfeit certain rights to vote, but you can't forfeit your property rights.
That's
Right.
correct. So no other question on that. I would just move to, there's a chat question about Landmark. There has been no further payments from Landmark. There's been much delay in getting Landmark to respond to our question, what's going on. There's been discussion about whether they would extend a tolling agreement, which expires at the end of October. But there's been no further movement from our request to talk to Landmark on that remaining $10.5 million in Landmark insurance. Okay, move the agenda. Tom, we're gonna have that meeting. Do you want to have that motion, or in essence, it's a moot point now?
Well, I should talk about it. The motion I want to make is that we meet with CNA and Ian Mitchell to discuss the status of the suits, and also to discuss with CNA and Ian Mitchell possible means, including mediation, to expedite settlement of the suits, and to agree with CNA on a path forward to rectify and settle all these lawsuits. And finally, to have CNA or the representative, which is probably going to be Ian Mitchell, to report back to us on progress weekly.
We're in
And
the
I'll,
then-
s-
process of
I'll
trying to
second
meet
it for
with
the
them.
sake of discussion.
Okay.
Jan?
We're in the process of trying to meet with them, right?
Yes.
Do we have we haven't heard from him about a meeting date?
We heard from CNA, they're not available this week. They gave us times when they're available next week. We haven't heard from Ian Mitchell yet, but I expect we will by the end of the week.
Yeah, maybe we have to, like say, this is urgent for us. I don't know.
Yeah, I
And
want to press
Wilson,
the point that this is extremely urgent that we get these settlements, these suits settled. The sooner we get them settled, the sooner we can, appeal to those who are holding out because we haven't settled the suits, and also to get a couple of the plaintiffs to sign.
Randy?
Yeah, we did make that point in a letter to Ian Mitchell that our main purpose is right now, our main thrust is to sell the building. And to do that, we need to get the lawsuit settled. And so that was when we asked and strongly asked to go for mediation on this, if that's what it takes to get this done. And yeah, but a part of your motion was also to get weekly reports, was it?
Yes, that was part of it.
That would certainly be nice.
I mean, that's to stay on top of this, to not let it, fall to the bottom of the pages, but to keep it at the top of the list, because that's probably the most important thing we need to get done.
I,
Yeah, Dan.
I want to be careful not to, I mean, we're not to burden him with reports unless he has substantive information, but we need his attention. We
A
need to get with
report to
him
me could
first,
be nothing
and
more than a
then,
phone call.
pardon me?
A report to me could be nothing more than a phone call reporting back to one of the officers
Well, I
of the
think we
board.
just, before we have a structure to it, I think we need our initial meeting with him. But
Any other board comments? I'm gonna call on Michelle as the comments.
So are you is this board saying that they are planning to mediate with the Porter plaintiffs to try to resolve this issue?
I think we are exploring that option, yes.
And is this board, with any money you use in the settlement, is that money that is coming out of proceeds that would be shared by all owners in the event if they choose? So you're saying you're going to take my money and the money of everybody on this
We need
call?
to stop commenting on this.
No,
Michelle,
Jan,
nothing to
why
conclude
should I
with.
stop commenting on this? This is something I understand the frustration of everybody with this. I get it. I get it. But you are asking owners who have already lost tens of thousands of dollars more. And if you're asking me not to be angry at my neighbors who I feel are keeping me and my building hostage and our owners hostage, they could ask for anything to settle this right now. We're all desperate. This is a cruelty that I can barely even fathom. So
Michelle,
I
that's
just want
not what I
everybody,
was saying.
I want everybody on this call to know any settlement with your neighbors is coming out of your pocket. And that is all I'm going to say, because if that doesn't do anything I don't understand it. And frankly, I'm just gobsmacked that people are still pursuing a lawsuit. I'm shocked. It is beyond my fathomability.
I just
Okay,
said we need to stop commenting on this as a board, in my opinion.
Tim, then Randy, then I'd like to make a comment.
Here's what we're exploring. CNA has said they will not cover damages. They will cover legal representation, and they will potentially cover settlement costs. So this money will not necessarily come out of our funds if CNA agrees to it as part of the settlement. So that's what we're exploring right now. We don't exactly know how this is going to work, but that's what we've been told, is that they will not cover a damages. They will not cover a damagement suit, but they could potentially cover a settlement.
Randy, do you have a comment?
Yes. Because of a contract that was signed by the previous board with Hunt, we have to pay their legal fees as well. And since they are defendants in that same suit, it's even worse than you think. So we're going to get lawyer fees from Hunt, our own lawyer fees. We're being held. I agree with you, Michelle. We're being held hostage, and we don't like the mediation idea, but you've made a lot of pleas, and I think a lot of us have made a lot of pleas to get this suit dropped, and it hadn't happened. So we don't know what else to do.
I would just say, in direct answer to Michelle's question, at this point, the board has not made any decisions. We haven't begun mediation. We don't know what the terms of any settlement would be. We haven't agreed to any settlement. We're just beginning to find out whether we can sit down and talk. Sally.
Well, I think maybe some of my question has been answered, but typically the result of mediation is that there is some kind of settlement. And am I hearing correctly that some of that may come from CNA? As opposed, you don't know.
Anything's possible. We don't know.
So then, before you agree to the mediation, so you'll meet with CNA and talk through what that strategy should be before you agree to the mediation. Okay, that's helpful. Yeah. Thank you. And then obviously, if it does go to mediation, there is the potential that I don't know what the plaintiffs are going to require in terms of a settlement. So I think it's still going to end up potentially part of it at least coming out of our pockets.
Yeah, we have to pay the mediator if nothing else. Yeah.
Yes, yeah, agree, agree. Thank you.
Yep. Tom?
Yeah, when it comes to mediation on the talks, I would try to get CNA to pay for the mediator, and I would not make it binding to leave us an out should we absolutely need it. But we need to start talking with these plaintiffs to find out what they want. The settlement may not be monetary. There's always that possibility. But we got to find out what they really want. And we're not going to find that all until we start talking to each other.
All right. So will you call, Tom, your motion to be what you sent around to the and what's on our agenda?
Yes.
So let me just read it then for the owners. Be it moved that we meet with CNA Ian, maybe Finney too, by the end of next week for the purpose of receiving an update on lawsuits, developing a strategy and timeline to resolve these suits, and begin to receive timely reports on this progress. And it was a second by Randy. Tim?
I was gonna second it.
Okay, that was seconded by Randy before. Jan, you had a question?
You just a comment. You changed it a little bit. I'm okay with it, but you said timely reports. I think Tom said weekly, but
Said week. I can live
Well,
with you.
weekly was in the email. This was, I'm not sure the process, Randy and Tom working out but that's the language in the agenda.
Tom, do you agree to is timely? Is that
I agree, timely will work.
Okay. All right. Any other comments? All right. Then all those in favor of the motion, raise your hand. Okay. 6-0. All right, moving along. Liens. Through a number of reasons, the liens had not been filed for quite some time. And Tracy and I have been working with Greg to make sure they were filed. Owners got 10-day letters, and we have moved a series of liens are now in effect. To really to move it forward, there are a number of policies that I drafted up, and I'll read them to you. Well, actually, let me turn the chair over to Tim because I want to make a motion.
All right. John, would you like to make a motion regarding liens?
Thank you. Yes, I would. Okay, 1, and there's a number of 7 bullets. The Hammond North Board understands that all owners are no longer living in Hammond North, but are still responsible for the monthly fees, circumstances that have never existed before August 8th, 2025. 2, all owners in arrears are responsible for their amounts in arrears. 3, the Hammond North Board will apply a uniform policy to all owners in applying liens to accounts in arrears. 4, the Hammond North Board will consider new liens in order of the highest arrears first. 5, new liens will not be filed if owners are paying their outstanding balance every month in 12 equal installments in addition to their monthly fees. 6, new liens will not be filed if owners are in arrears less than 2 months of their 2024 monthly fees. And lastly, the board will review a unit's ledger for the past 12 months before applying for a lien. And I just comment before I ask for a second that the ledger is a listing of every debit and credit to each owner's unit. You're the chair, Tim.
Second. I second him.
Up to you to Tim.
Any discussion regarding John's motion? Dan?
could you do a brief explanation of why our Blue Book and other policies in place were not sufficient and we needed to draft this?
Yeah, well, I would say 1, the Blue Book and the governing documents are sufficient to say that a lien can be applied. But in a situation where there are a large number of liens that you have to have a really clear policy how they should be applied. And especially where we have a lot of liens, we can't go through all of them at the same time. So we have to figure out what we should do first. And it should be the ones, as I said, the ones that are the highest in arrears, which in general are the people who are the longest in arrears.
Thank you.
Any other questions or comments? All right. All those in favor of John's motion on liens, raise your hand.
Hmm.
6-0. John, I turn the meeting back over to you.
Okay, thank you. How can they get removed? I'd say contact me or any member of the board, but basically I believe it's a form that can be filed by, liens are filed by Finney at this point to the courts. If we tell them a lien should be lifted, then they can file that the lien should be lifted. Once a lien's in place, then actually until we have a set payments, like as I mentioned, 12 installments and your monthly fee, then I believe, Greg can correct me if I'm wrong, we don't accept any payments, not that we don't want to, but if we accept them, then the lien basically legally is lifted. So until we have an agreement that we have a payment plan, then the lien is in effect. Legal fees, somebody else asked, legal fees are part of the lien. So there's late fees, there's interest, and legal fees that would be applied. And basically the way liens will come out is when the building is sold, this will come off the top back to the association and not be paid to the owners. Any other comments? Okay. All right. Move the agenda. That's what we had. Is there any old business from any of the members? Any other announcements? Okay.
Has anyone had time to look? I've been doing other things. The chat, is there anything in there that we haven't commented on?
We've covered most of what's in the chat.
Okay.
Is there any feel for how much the legal fees would be to put a lien on?
I don't know, but basically it's a fairly simple form. It's very similar to every lien is similar to the other one. There's a legal description of the property, how much is owed, the percent interest in the common areas, the total that's owed, and it's filed with the court. All right, no other new business, new items, any of the members of the board want to bring up? All right, then we'll adjourn the meeting and we'll adjourn it into executive session. Thank you, everybody.
Before you hang this up, John, I want to copy the chat. Unless somebody else is.
Okay. Let me see.
Wait a minute, I'll have it in a second. There's a lot. Got it.
You got